For today's keynote session, I'm delighted to welcome Professor Fatima Khan as part of the University of Cape Town Law Faculty. As our closing keynote speaker, Professor Khan brings the perspective of someone who formidably combines the roles of researcher, practitioner, and activist. She's published extensively in the area of refugee law, including 2 books on refugee and immigration law in South Africa, and has a specific interest in the integration of refugees in the host community. At the same time, of course, Professor Khan is principal attorney and director at the Refugee Rights Clinic at the University of Cape Town, where she's engaged in extensive strategic litigation and also teaches refugee law to undergraduate and postgraduate students there. The title of this year's conference is Aging Gracefully, the 1951 Convention at 70 years. The title of Professor Khan's keynote presentation responds to this by addressing states in the Refugee Convention, circumventing, but not blatantly disregarding. I know that we're all very much looking forward to hear what Professor Khan has to say under this title. The plenary will proceed with the keynote presentation of some half an hour, after which Professor Khan has kindly agreed to respond to selected questions and comments from other conference participants. So during the session, please do pose your own questions and comments to her by typing them into the chat box on Zoom, and I'll try and convey as many as possible to her once we reach the time for discussion. Please do remember that the session is being recorded and will be posted on the RLI website as a podcast. If you don't wish to appear in the podcast, then please leave the session now. Without further ado, in that case, I'd like to hand over to our keynote speaker for the final closing session of the conference. Professor Khan, you have the floor.
Thank you, David. Good afternoon, David. Good afternoon, everybody. Thank you for inviting me to participate in this conference today. It is indeed an honor, and I am delighted to be here. And thank you, David, also for your very generous introduction. Now, day 3 of any conference is well known as the day that conference fatigue sets in. But thanks to David and his excellent team and the excellent planning of half-day schedules, today feels like a day one of the conference for me in terms of energy. However, it is of course very likely that what I plan to say have already been touched on by previous presenters. In that case, David, I'm going to take the opportunity to either respond or support points made by previous presenters. So just a little bit of a warning, I'm likely to go over more than your 30 minutes. And in my preparation for today's presentation, I have come across numerous papers prepared by refugee law scholars for almost every decade of the existence of the Refugee Convention. And these scholars too, like myself, were invited to provide comment on the significance of the convention. I'm fascinated by the titles that my peers have come up with. Relevant or redundant. My personal favorite is crucial, cornerstone, clinging to the past, outdated and outmoded, time to retire. I have read most of these papers, and I agree with Professor Jane McAdam, who in her presentation on the enduring relevance of the convention says that we have all heard the accusations leveled at the 1951 convention, that it has passed its use-by date, that it's too old to respond adequately to the displacement challenges of the 21st century. We are also told, she says, that it is at once too narrow and too broad, to simultaneously blocking and facilitating access to protection. Now we are asked by David and his team, is she aging gracefully? We've heard what Professors Hathaway and Shimini had to say, that she's hobbling along or that she's a sassy 70-year-old. And most of these papers that were written in the past decades reflect on the continued relevance of the convention for the refugee, whether it can adequately define the refugee facing current challenges, but I believe in the last decade, the focus has shifted to the action of host states and their ability to receive and protect the refugee in terms of the convention. Hence, my focus today is on the state's relationship to the convention, because how states relate to the convention ultimately defines the standard of treatment provided to refugees. And depending on how genuine the commitment of states is to implement the convention, either generous or restrictive interpretations of the convention will emerge. So are states genuinely complying with the convention, or can it be alleged that they are contravening it? My proposition today is that states are finding innovative ways to circumvent rather than contravene the convention. Thus, my title for today is Circumvention versus Contravention. But why circumvent? Of course, we know that what the convention does do is articulate fundamental rights and duties owed to and by refugees. In many ways, the convention can be seen to be ahead of its time with the extensive inclusion of rights. Additionally, these rights have, of course, been bolstered and extended by international human rights law. States are therefore well aware that to denounce the Refugee Convention would not undo these obligations. During the first panel, we heard Jean-Francois say that it's not likely for democratic states or European, I think it spoke specifically about the EU, to openly defy these international human rights laws. But for whatever reason, which we are not discussing here today, these states do not want refugees in their states and have therefore come up with they've become very inventive in their dealings with refugees to avoid their obligations under the convention. Unfortunately, in the last decade, we have seen many innovations. And for now, I will call it innovations. And much has happened in this last decade. And as a result, the relationship of many states, but particularly the states of the global north to the convention has changed. But it is apparent that states are finding ways to minimize their obligation to refugees. Throughout the history of the convention, states that have ratified the convention have, however, tried very hard to convince the world that they are complying with the convention. And this is evident from the numerous cases brought before our national courts, before regional courts. And these cases are an indication of how hard the convention has fought to remain relevant. But before we look at any one of these ways that states have tried to circumvent the convention and the legality of these actions, I would like to take just 1 minute to put my work, my region, and my country into context. So I am from the University of Cape Town Refugee Rights Unit, where I am the director. And so besides engaging, and as David said earlier, in teaching and research, work ordinarily undertaken at universities, the Refugee Rights Unit also incorporates a law clinic. And at this clinic, we consult with approximately 5,000 refugees every year. And most of these refugees come from Somalia, Ethiopia, Burundi, Rwanda, and the DRC. These are refugees that have survived brutal wars. Some of them have survived genocides. And as you can well imagine, that after nearly 20 years of interactions with such traumatized persons on a daily basis, it has had an impact on my teaching, on my research. It has in fact filtered into every aspect of my work. I have refugees in my physical space on a daily basis. And so in our clinic, we assist, with status determinations, detentions, deportations, access to socioeconomic rights, etc., etc. So I speak to you as an academic, but as a practitioner as well. And as a matter of interest, and this may be of great interest to many of you, a large percentage of the funding for this refugee rights unit comes from the UNHCR. This clearly makes for an interesting dynamic in my practice. I also speak to you as an African. In Africa, in 1967, until 1967, the 1951 Refugee Convention did not matter to refugees in or from Africa. These refugees were not protected by the 51 Convention. And they were not protected because of the temporal and the geographic limitations of the 1951 UN definition. It was only when these were lifted by the 67 protocol did refugees in Africa and from Africa benefit from it. But very soon thereafter, just 2 years later, the continent produced its own regional refugee document, the 1969 Refugee Convention, with an extended definition, and refugees do not have to prove individual persecution. The fact that their lives are at risk because of war, occupation, or events seriously disturbing the public order is sufficient. But alas, this document contains no socioeconomic rights, and as many of you are well aware, no right to freedom of movement. In fact, no right that will ensure the meaningful integration into the host states. So unfortunately, African states, when they ratified the 1951 Convention, they took full advantage of the option to sign reservations to the numerous and generous rights of the Convention. Now we have Article 42 on the screen. And I'm going to, like Professor Way, I'm going to take almost a pause here, and I'm going to draw your attention to it in the same way that he drew our attention to it. He almost stood still and he said, let me say this to you. He said, most people, when they look at the 51 Convention, they look at Article 1, they skip everything in between, and they look at Article 33. That is the case. I mean, I acknowledge that that is the case. But if you look at the reservations that states are allowed to sign to the Convention, Professor Hathaway, of course, you're aware of this. Most states in Africa have chosen to sign reservations to everything in between 1 and 3, except for Article 3, which is non-discrimination, 4, the right to religion, and 16, which is access to courts, which they are not allowed to sign reservations to. So yes, in Africa, everybody skips everything between 1 and 33. And as a result, we have in Africa what I unapologetically refer to as the warehousing of human beings. We have a proliferation of refugee camps, refugees living in protracted refugee situations, languishing here for more than 50 years. So can this be seen perhaps as a form of legitimate circumvention of the 1951 UN Convention, right? I also speak to you from South Africa. We have in this country ratified both the UN Convention and the OAU Convention shortly after we became a democracy. And because of our history as a country, we did not sign any reservations to either of these documents. So refugees in South Africa are entitled to the full range of rights. And because of the human rights focused interpretation of the convention, refugees have benefited generously from this convention, and this notwithstanding, of course, the xenophobia that takes place in my country every few years. But despite this comprehensive legislation, We have unfortunately noted that, like several other states in the last decade, South Africa too have been trying to find ways to circumvent refugee laws without showing disregard to the core human rights of the convention. During question time, please feel free to ask me questions on South Africa and my practice. But let us look a little bit more closely at this circumvention. States looking for ways to minimize the obligation to refugees is, of course, nothing new. Circumvention is also not new. We have witnessed over the years minor circumventions. We have witnessed drastic circumventions. For instance, the poor allocation of resources to asylum governance, the negative portrayal of the refugee. States have also traditionally tried to circumvent the convention through delayed asylum processing, and the lack of procedures have clearly created a gap for circumvention. States have also, through the restrictive readings of the principle of non-refoulement, managed to do this, and in some cases they have been successful in the narrow application of the principle. But since its inception, states have been trying to find ways to circumvent the obligations under the conventions. And this is, of course, continuing, but states also continue to argue that this is not the intention. They are not setting out to contravene so we're looking today at the issue of jurisdiction, because this has been one of the main ways that states have tried to contravene, and the literature refers to it in so many words. We have extra-territorialization, we have de-territorialization, and now we also have externalization. And at first glance, these concepts look like exactly the same. Looks like exactly the same concept, but in my opinion, they are not. They are, in fact, a perfect display of the innovativeness of states to circumvent the obligation. And also, you know, we have, in the last decade in particular, the refugee protection regime has faced many challenges, and there have been new introductions and new ways of looking at things. So we have the Global Compact and we had the New York Declaration. So I think I am going to take some time to look at how the UNHCR has handled this. Have they also fallen into the trap of circumventing, but not blatantly disregarding the convention? And I am reminded that I'm funded by the UNHCR. So, and I will end off by looking at whether this new trend in circumvention, whether it can be legally challenged. What is it that we as refugee rights advocates can do to stop this from continuing? But also more broadly, I will share some thoughts on oversight of the convention. So with regard to the principle of extraterritorial application, we saw this almost 30 years ago in the well-known case of Sale versus Haitian Centers Council. In that case, the US Supreme Court held that the principle of non-refoulement did not have extraterritorial application. It was deemed to be applied only within the territory of the contracting states, which means that interception at the high seas did not amount to a violation of Article 33. Under that precedent, the United States maintains the policy of interdicting individuals at sea and returning them to the country of origin, unless, of course, they claim they are refugees. But they are not likely to be informed by these Coast Guards that you may, or informed by the Coast Guard that this is what they can do. And what we have is, as Paul Frelick says, only a tiny number of Haitians, you know, that are interdicted on the high seas have ever had the asylum claims heard. And this is, of course, a judgment in the US Supreme Court, and it hasn't been overturned. It is the state in the United States at the moment. But Europe has its own version of Sale versus Haitian Waters Council in the case of Hirsi-Jama versus Italy, where the European Court of Human Rights have held that applicants who have indeed never reached Italian soil had nonetheless, when they were intercepted on the high seas and been transferred onto the Italian military ships and returned to Libya, they have come under the jurisdiction of Italy. I think it is at paragraph 81 of the judgment where they said that under that these applicants were under the continuous and exclusive de jure and de facto control of the Italian authorities, and therefore Italy had effective jurisdiction over Hirsi-Jama and others on the boat, and therefore Italy could not shirk its duty. And so we have here two different outcomes on exactly the same issue. When we look at deterritorialization, now is this just a new name? Clearly it's not a new name. And it is apparent that this is a response to the argument that the principle of non-refoulement does have territorial application. States have come up with new innovations, and they've come up with deterritorialization, and they've come up with externalization, right? In deterritorialization, this is where destination states have abandoned part of their territory. They have deterritorialized, and externalization, of course, is where the destination state is not strictly speaking or directly involved in restricting the entry or blocking an asylum. This is left to a third party. And we've heard much and very interesting, we've had interesting presentations on this very concept over the last 2 days. But deterritorialization in itself is not new. Way back in 2001, for example, Australia had already excised Christmas Island, Ashmore Reef, the Cocos Island, and other territories from its migration zone, and felt and at the time argued that they were not responsible for these persons. But well known also, of course, is the practice where states have established international zones which are designed to be legally free on the state's territory, and especially in airports, where states have claimed that jurisdiction do not apply. Nevertheless, various courts have decided that international zones fall under the such international zones fall under the jurisdiction of the country. In Europe, you have the Amor versus France case, but here in South Africa, we have the case of Abdi and another versus the Minister of Home Affairs and another. And in this case, our Supreme Court of Appeal held that what the Department of Home Affairs referred to as an inadmissible facility in the airport, that it does fall directly under South Africa's jurisdiction because it forms part of South Africa's national territory. And therefore, anyone held at that facility had the right to access court, and the Department of Home Affairs was obliged to assist them, and these applicants need to show no more than they were persons who might qualify as refugees. I would like to recommend Professor Ben Habib's article on deterritorialization. I think it really it really bolsters this argument, and she goes on to describe the consequences of deterritorialization as the delinking of the bond between territory, jurisdiction, and the public, in whose name and with whose authorization law and coercion are presumably exercised. Early on, when I referred to the international nature of human rights and how that has provided an additional protection for refugees, so therefore it's not difficult to see how deterritorialization is therefore potentially disastrous for the refugee, but that it at the same time poses a serious challenge to international human rights law. With regard to externalization, and it's clear that because arguments around extraterritorialization have been defeated and that they no longer protect states from their liability, which is why states have created new forms of non-entree policy practices. And these new forms of non-entree policies require international cooperation to prevent onward movement to specific destinations by any kind, these international cooperations have either been with countries of origin or countries of transit. And this, I'm not going to go into detail about this because it has been sufficiently discussed over the last 2 days, except for to say that, of course, the EU and several other states believe that this is one way that they can insulate themselves from liability, because the action does not take place on this, under their sovereign authority. It takes place under the sovereign authority of another country, and they assume that such actions are free from legal risk because, after all, international law says that states are liable for violating the principle of non-refoulement when they are acting within their own jurisdiction or at their state's borders. So, Europe has, of course, seen a development of this, at first starting with ad hoc arrangements and bilateral agreements, but it has developed, clearly developed into a more sophisticated arrangement, and these externalization actions now form part of mainstream migration and asylum policies for these states. Just to mention 2 examples and of this, of course, the most consequential one amongst these is the EU-Turkey deal in 2015, but this has come to an end now. But far more disastrous have been the EU-Libya deal, spearheaded by Italy, which further partnered by Libya without the EU being involved. And so we can ask ourselves, how did we get here? And it's a complicated answer, of course, but one of the answers can be that it is because the convention itself lends itself to this. The convention is state-based. It is a state-based refugee regime, and this is what allows states to take this kind of individual action, whether it's a bilateral agreement or a diplomatic interaction. I believe Professors Hathaway and Gameltoff Hansen have outlined several of these in their article, their recently written article. But before we look at how we can prove that the circumvention amounts to contravention or whether it can be legally challenged, I want to, as I said earlier, I want to briefly reflect on the UNHCR and how it could possibly be seen as circumventing itself. Now, as the custodians of the 51 Convention, the UNHCR, of course, continues to vigorously defend the Convention as it is supposed to, But the UNHCR cannot deny that not all refugees are protected by the standards set by the 51 Convention, not even those who find themselves in countries that have not signed any reservations to the Convention. And whenever I listen to UNHCR's defense, I am reminded by Professor Hathaway's conceptualization of the 51 Convention. When he visited my university 2 years ago, he very famously stated, and perhaps has made the statement before, he said, what the UN Convention offers all refugees is a Cadillac. And he has huge praise for the drafters of the convention, but who fought very hard to offer this Cadillac. But we know that when that convention was drafted, they had the European refugee in mind. There is no getting away from that, right? So therefore, the drafters could not have anticipated interceptions on the high seas or concepts such as externalization, deterritorialization, or extraterritorialization. And I do believe that it is since 2015, or maybe just a little bit before that, when Europe began to experience mass inflows of refugees, that we have seen a shift and a change, not just from UNHCR, but definitely from UNHCR and several others. I mean, UNHCR led us in the New York Declaration. We give them the credit of the Global Compact on refugees. And it's not, perhaps the mass inflow into Europe is not the major reason or the only reason why we see this change, but in my opinion, it is definitely a reason for this change. We also see an increased narrative around burden or responsibility sharing. In fact, it has reached fever pitch over the last few years. Yet this is a concept that has been around in the OAU Convention since 1969. So I do believe that in some ways UNHCR they have reneged on their strong support for the convention when they started to use the Global Compact on refugees in their operations more than the 51 convention, right? And I don't mean to be overcritical of the UNHCR, and I have been invited by my UNHCR colleagues here in South Africa to say, Fatima, as long as the criticism is constructive, go ahead. So let's see. Let's see if this is constructive. So a short while ago, a friend and a colleague brought to my attention the following. She writes that the UNHCR appears less and less to refer to rights or obligations of the state. Current UNHCR references, for example, to livelihoods. There's an abundance of reference to livelihoods, whereas 10 years ago, the same references referred to working rights. So it is subtle. It's probably not a conscious decision, but it's all in the use of the language. It's UNHCR's preference to use the terminology of the Global Compact rather than the convention. I don't believe that they are consciously backtracking, but the introduction of words and phrases that take away the strength of the convention rights can over time be seen as signifying a change in the commitment to the rights as outlined in the convention. So the language of self-reliance and livelihood are paramount in UNHCR's communication with myself as a legal partner, but it is also wholeheartedly embraced by social implementing partners of the UNHCR. And self-reliance and livelihoods are, of course, the language used in the GCR. It is also a language that is demanded by the donors since the GCR. In the past decade, or maybe just slightly longer than a decade, the UNHCR has also started to refer to movements of people seeking asylum as mixed migration. They later changed it to mixed flows. Just by the using of this phrase, I believe they have given ammunition to governments to renege on their responsibility to refugees and have consequently weakened Article 31 and the right to non-penalization for illegal entry. And ever since the UNHCR use of this phrase, I have witnessed how South African policy has changed, and it's largely been informed by a narrative that the asylum system is abused and it's collapsing from illegitimate claimants, and they have developed this concept of the bogus asylum seeker. On another point, on Wednesday, Professor Hathaway spoke very eloquently on how the recognition of refugee status is a declaratory act. And he explained how the strength and the value of that for the person seeking asylum. So therefore, UNHCR's excessive use of the term asylum seeker, especially here in South Africa, is very odd. In a recent report written by UNHCR, just a 4-page report on South Africa, I noted that they mentioned the term asylum seeker 32 times. Yet there is no reference to the term asylum seekers in the UN Convention or the OAU Convention. And I believe that, well, the usage of this term has become widespread and it's detrimental to refugees, especially since in the last few years, we have noted that the term asylum seeker has become code for illegal immigrant or economic migrant. And as the custodians of the convention, I'm appealing to UNHCR to reinforce the language of the convention, to reinforce the convention's approach to persons seeking asylum. I believe I've gone way over time, and I'm going to conclude by making 2 points. And I'm going to conclude by, I said earlier, let us look at how we can confront these circumventions. So as a practitioner, as an advocate for the rights of refugees, I believe it is crucial that we challenge these circumventions, that we challenge them in our courts of laws, whether these are national courts or whether these are regional courts. And I'm pleased that externalization is currently being challenged, or there's a launch that case has been launched in the form of SS versus Italy. And I do believe that the UNHCR not only owes refugee, civil society, but also national and regional courts a huge debt of gratitude for helping to uphold the rights in the convention. As a practitioner, I can assure you it is no easy task to challenge these concepts in court, these new innovations by states in court. If we look, for example, at the Hirsi case, we know how difficult that was, where Italy alleged that most of those powers attorneys that they had defects, and of course this is an approach used by courts where they find fault, procedural fault, and they use that to strike out cases. And we know that has happened in 2 years prior to the Hirsi case in Hassan and others versus Italy. It's also not likely when you find somebody at an international zone in an airport that they happen to have the phone number of a lawyer in that country in their back pocket, as Mr. Abdi and his partner had in South Africa. Mr. Abdi was a client of mine before he left for Namibia. He had my phone number. He had the phone number of the UNHCR voluntary repatriation officer. And that is how, just because he knew somebody, nothing easy about bringing these cases to court. But we also know that national courts and regional courts have their limitations, even though in their best efforts, and we know that there's lots of collaboration between these courts and UNHCR and the International Association of Refugee Law Judges, etc., etc. But besides, in spite of all their best efforts, there is a fragmentation. And so I'm going to conclude by reiterating the calls made by Professors Shimini and Hathaways for an independent tribunal and an independent body of experts, so that to ensure the integrity of the convention. Thank you very much, David.
So much. Thank you ever so much, Professor Khan. It's It's a real privilege to listen to you talk about this particular conference theme, given your perspective as both a renowned scholar and somebody who's been in the field of practice with such lengthy experience. I think your key point about, we need to understand how states relate to the convention if we really want to understand its place in the present and going forward as well is absolutely key. And thank you ever so much again for pointing to the need to challenge these kind of circumventions. And I think you've put your finger right on the issue there, that circumventing rather than blatantly disregarding. In other words, thinking about the letter of the law rather than the spirit is part of the problem here. It's a really great presentation. We've had a number of questions, and I'm just going to pose them to you one by one, as in previous sessions, if that's okay. So the first question that we have is from Jean-François Dorieux. And he said, "You're so right to identify as a particular weakness of the 1951 Convention the fact that it allows reservations to the bulk of its provisions. Do you think that a strictly supervised system of time-bound derogation in mass influx emergencies would be preferable to such openness to reservations? Reservations," he says, "are annoying because they apply all the time to all refugees in all circumstances, whereas derogation would only be justified in cases of declared emergency." So I'll give the floor back to you, Professor Khan, and we look forward to your thoughts on that question.
Thank you very much, Jean-François, for your question. It's not an easy question, right? So under what circumstances would I advise derogation? I'm going to be a pragmatist and I'm going to be a realist here. I would not be opposed. I would not be opposed to derogation in times of an emergency. But I do believe that these emergencies should be clearly defined and that they should be time sensitive. Thank you for your question.
Many thanks indeed. We've got quite a particular question next, which is around the European context. And it asks, in your rightly condemning the Italian circumvention of the Geneva Convention with regard to non-refoulement, what relevance do you give to the inflexible opposition of the majority of EU member states to the modification of the Dublin regulation, which is used for determining the state responsible for examining asylum applications? So I think the question is, balancing those two things up, or seeing them one in each hand. Do you think that one relates to the other, and should we be relating those two areas of practice?
So I speak to you as a South African, right? I have minimal knowledge. I have minimal knowledge on the Dublin Convention. I have more or less an idea of what the Dublin Convention is, and so I am going to plead. I'm going to plead ignorance. I'm going to plead ignorance when it comes to the Dublin Convention. I do understand that your bordering states are overburdened. I look at Italy that is overburdened. I look at Greece that is overburdened, and I question whether this is because of the Dublin Convention. It probably is because of the Dublin Convention, and it does scare me because my country in our region has in many ways they are trying to adopt this kind of approach in that wherever the first country of safety that you've reached, that is where you should apply. And I've noted with great concern how South Africa wanted to sign bilateral agreements with some of our neighboring states. So that's my little bit of an input there, but not a specialist in any way on the Dublin Convention.
Many thanks, and that's well understood. I think, the perspective that you give from South Africa is so valuable to this conference. And just actually maybe building a little bit on your response to that question, if I could just insert one of my own. I mean, if we think about kind of how states relate to the Refugee Convention, different states do relate in rather different ways. who do you think sets the trends here? And if they're not good trends, then how do advocates and activists and scholars like ourselves kind of insert ourselves into those conversations and, try and deflect some of the, if you like, less benign influences that perhaps some of these quite influential states look like they are pushing out towards other parts of the world?
Well, a simple answer is that it's clearly the more influential states that are leading the way, and states that and we can't deny that donor states probably play a much bigger role than any other state in shaping the way the refugee protection looks like in the world today. In my region, it's clearly a country like South Africa who is stronger than its neighbors that can lead the way. So I do believe it is the more influential states that lead the way. But having said that, I do believe that UNHCR plays a massive role here in the manner in which they engage these influential states. I do believe that UNHCR should play a much bolder role when they are engaging influential states, and where they are noticing and picking up on trends that are, like I've called them earlier, these new innovations. I do believe that UNHCR should step up, that they should address these, whether they are having one-on-one meetings with these states or in these regions. But